Hello, everyone, and welcome to the Aspen Author webinar series. Today's topic is the Fourth Amendment and rights to a fair trial. Before we begin, I have a few housekeeping items to review. First, the audio for this webcast is through internet only. Please use a headset or earbuds to listen to this presentation through your laptop or mobile speakers. Second, this is a one-way communication channel. That means you can hear us, but we can't hear you. If you have any questions, please use the chat feature to the right of your screen. And now I will hand it over to Anton to introduce today's presenters.
Hello, my name is Anton Yakovlev, and I'm a managing editor at Aspen Publishing, working on major electives, second L courses. And it is my great honor today to introduce our presenters, Erwin Chemerinsky and Lori Levinson. Erwin Chemerinsky is the Dean of Berkeley Law School and Jesse Chopra Distinguished Professor of Law. He is the author of 14 books, including leading case books and treatises about constitutional law, criminal procedure, and federal jurisdiction. His most recent book with Lori Levinson is the 4th edition of Criminal Procedure that was just published by Aspen Publishing earlier this year. His other recent books are Presumed Guilty, How the Supreme Court Empowered the Police and Subverted Civil Rights, and with Howard Gilman, The Religion Clauses, the case for separating church and state, from Oxford University Press, as well as Constitutional Law from Aspen Publishing. He's also the author of more than 200 law review articles, a contributing writer for the opinion section of the Los Angeles Times, and writes regular columns for Sacramento Bee, the ABA Journal, and the Daily Journal, and frequent op-eds in newspapers across the country. He frequently argues appellate cases, including in the United States Supreme Court. In 2016, he was named a Fellow of the American Academy of Arts and Sciences. In 2017, National Jurist magazine again named Erwin Chemerinsky as the most influential person in legal education in the United States. In January 2021, he was named president-elect of the Association of American Law Schools. Lori Levinson is the professor of law and David W. Bertrand Chair in Ethical Advocacy at Loyola Law School, where he teaches criminal law, criminal procedure, white-collar crime, ethical lawyering, evidence, and advanced trial advocacy. Levinson joined Loyola faculty in 1989 and served as Loyola's Associate Dean for Academic Affairs from 96 to 99. She's been a visiting professor at UCLA and USC, and a D.N.L. Strauss Distinguished Visiting Professor at Pepperdine School of Law. In addition to criminal procedure with Erwin Chemerinsky, Lori Levinson is an author with Justice Brian Hofstadt of the forthcoming Evidence Law, Practice, Problems, and Policy, which will be published by Aspen in the fall of 2022, so stay tuned. She is the author of 14 books, including Levinson and California Criminal Procedure from Thompson Reuters 2020, and Complex Criminal Litigation, Prosecuting Drug Enterprises and Organized Crime from 2019 with Jimmy Goulet and Mark Bonner, as well as many law review articles and other publications. Professor Levinson is the founding director of the Loyola Project for the Innocent, the Loyola Center for Ethical Advocacy, and the Fiedler Institute on Criminal Justice, and senior faculty for Loyola's Journalist Law School. So with this, I'll hand it over to Erwin Chemerinsky.
Anton, thank you so much for that kind invitation. Thank you for inviting us to do this program today. It's a great joy to have the chance to write a book with a dear friend. And it's been wonderful to do the criminal procedure case book with Lori. It's hard to believe that it's already now in its 4th edition. What we want to do today is talk about some of the cutting edge issues with regard to the 4th Amendment. So you have a roadmap. We're going to focus on 6 questions. First, how is new technology affecting the 4th Amendment? Second, does the 4th Amendment allow searches of electronic equipment at the border? Third, what's the state of the law with regard to excessive force? Fourth, why are no-knock warrants so controversial? and what might be done about them? Fifth, how much discretion do judges have in dealing with pretrial publicity in voir dire and high-profile cases? And then finally, we'll talk about the Supreme Court's recent decision in Thompson versus Clark, what it means with regard to the Fourth Amendment in Section 1983 litigation. We'll save about 15 minutes at the end for any questions that you have. And with that, let me turn it to Lori to talk about the first question.
Thank you so much, Erwin, and I want to thank all of you for joining us today. It is a privilege, an honor to be with my dear friend, Dean Chemerinsky. And we have worked on this book. It's an act of love. And doing this program is to give you an idea of sort of big picture issues that come up. I teach criminal procedure regularly. Erwin does as well. So we understand what it's like both to have the book and then make it come alive in the classroom. And that's why I think that this overall issue of how is new technology affecting the Fourth Amendment is not such a new issue at all. If you think back all the way to Katz, what has been driving changes in new cases by the Supreme Court is very much the issue of technology, even Katz itself, that involved a phone booth. And they moved from the Olmsted physical intrusion to now you have listening devices, sort of gave us an idea that technology would require us to think about rights of privacy in the Fourth Amendment in this new era. And it's continued on, whether it be helicopters and planes over property, new technology at the time, and then thermal imagers. You all remember those from the Kylo case, where Justice Scalia stepped up and said, we better have in place some approach to deal with technology. And at the time, he threw out the idea of, well, okay, if it's a home, and then if it's a new technology, but if it's in general use, we're not going to call it a search. And then if it's capable of showing intimate activity. But that's a standard that really hasn't held well as we see the changes in technology. Because a lot of technology now not only affects people in their home, but in their other homes, namely their cars and their cell phones and out in public. And it used to be easy for the Supreme Court to say that what you did in public was not covered by the Fourth Amendment. What you do in private might be, but that's harder to say now, given how much ability the government has to collect information about your life with the new technology. Now, we saw this part of the issue develop through the cases of Jones. You'll recall that's one where they put a beeper on the car. And Justice Scalia, again, was trying to deal with technology, but in a very odd way, using 18th century trespass law to say, we'll add that to the caste standard. And it was Justice Sotomayor in her concurrence who said, we need to start thinking differently about the Fourth Amendment. We need to see it more on the mosaic theory. Even if you're out in public, if they're collecting this information from your cell phone and know about what you're doing 24/7, shouldn't that violate the Fourth Amendment? But that wasn't spelled out completely yet in that case. So we subsequently saw Riley, where the Supreme Court again noticed that electronic devices, a new technology, made that old standards, searches incident to arrest, where you could go through a wallet, wouldn't apply because there's way too much information in your cell phone. It's not just like anything else you would have on it. And the most recent case, of course, is the Carpenter case, where they were using the GPS pinging on the cell phone. And they collected information from 7 days, 24/7. And the Supreme Court said in that situation, even though they're traveling in public, and even though they made the information available on the third party doctrine, it could still be a search. So what I see, and Erwin will have his thoughts, is that this new technology is making us rethink the Fourth Amendment and some doctrines that have gone with it. Issues like the third party doctrine. We have no way to do much of our technology without involving a third party. But would that mean that you wouldn't have Fourth Amendment protection? So I see a lot of developments moving in this area, but I don't see complete clarity because the Carpenter case does not tell us. What if it's not 7 days? What if it's 6.5 days? 5 days. And who knows what the next technology would be. You know, Erwin, we've got technology from smart cars, facial recognition, license plates, drones, body-worn technology, internet browsing, smart doorbells. All of those things affect people every day in their lives. And when the government gets involved, it gets the court's attention. Erwin, you got some thoughts on this?
I think it's a terrific presentation. Where I'd start is with Carpenter, because Carpenter was a 5-4 decision. Roberts, Ginsburg, Breyer, and Kagan were the majority. Thomas, Kennedy, Alito, and Gorsuch dissented. Remember, Ginsburg is no longer on the court. It was replaced by somebody far more conservative in Barrett. I believe that even if Kavanaugh votes the same way that Kennedy did, probably likely in this instance, and even if the newest Justice Jackson votes the same way as Breyer, Kavanaugh and the new justices, I think Carpenter likely would come out differently today than it did in 2018. I think it likely would be now Thomas, Kavanaugh, Alito, Gorsuch, and Barrett is the majority the other way. Well, I don't know that that means the Supreme Court's going to overrule its decision in Carpenter, but I also don't know that it's going to extend it or apply it. So what are some things that this might mean in the future? First, you mentioned the third party doctrine. I think Chief Justice Roberts' opinion was at best ambivalent around the third party doctrine, saying the court wasn't going to overrule it, but the court wasn't going to extend it. The court might be much more inclined to follow the third party doctrine in the future. Second, what about the Thomas and Gorsuch dissents that want to focus on determining whether there's a Fourth Amendment violation by whether there's an invasion of property? What it used to be under Olmstead versus United States, 1928, that Katz overrules. Will Thomas and Gorsuch go back to something like that? And might they have a majority given the increasingly conservative court? If you read the Thomas dissent in Carpenter, he spends page more criticizing Katz in the Katz test. Might there be a majority to rethink Katz and what would replace it? And you gave a good list of new technologies. There's so many that are coming up. What about where there are cellular tower dumps, where the police obtain a list of all of the phones that were connected to a cellular tower at a particular moment in time to see who's match up when there was a crime? Or what about the geofences, where the police for a particular area find out all of the cell phones that were in that area at a particular time? What are the warrant requirements here? How does Carpenter apply? So it's a very exciting time to be teaching criminal procedure in Fourth Amendment because there's all these cutting edge issues. But my bottom line, Lori, is I agree with you that I think there's enormous uncertainty about where the court is going to go, not the least of which because of the change in the composition of the court since Carpenter.
And I agree with you, Erwin. I also agree that for teaching our students, they're going to need to know the traditional doctrines to understand where the changes are coming. And speaking of changing, let me go to the next issue, which is the question of, does the Fourth Amendment allow searches of technology, electronic equipment during border searches? And so we see this bleed over of technology into traditional doctrines that were developed at a time when you didn't have this type of search at all. What we're referring to are searches at the borders, and we all know that the border could be the physical border, but it often is an airport or a port as well. And under the traditional law, because the sovereign has the right to search everybody going in or going out, that they didn't need any suspicion at all to do searches of persons and the items that they were carrying. But all of a sudden, people are carrying their lives. I brought a show and tell, right? They're carrying their phones, they're carrying their laptops that, again, have so much information on them, especially when you see them in light of the Riley case. That should the same standard apply, that the border officials don't have to have any suspicion to not just physically open up your laptop, but to turn it on and see what comes up. And there have been a split in the court, although the most recent decision, Erwin, was from the First Circuit in 2021, Al-Assad versus Mayorkas decision, where the First Circuit said, as other courts have, that no suspicion is needed, that they're going to treat the search of a laptop and the phone just like the search of anything else. And they put that word routine on it, although I don't think that's really what it means. I think they say it's not too invasive, even though it has all that information. This is an area that has not been decided by the Supreme Court yet. It's not currently on the docket, but I'm not sure that it might not be in the near future, because courts can split on this. And moreover, what we're operating now with is a directive from the Customs and Border Patrol. They put out a directive 3340-049A. Don't have to memorize that. But basically, they've given authority to their people to do these types of searches and ask for cooperation. That's another big deal. Not tell people you don't have to cooperate, but ask for cooperation to get passcodes and to do searches. Where they've drawn the limit is to use the devices to get information that might not be in the actual device, might be elsewhere out on the cloud and internet, because maybe that is too invasive. So there are two bills that were actually offered up in Congress on this. Neither one has passed yet. One was 2694, the Senate bill that would actually require reasonable suspicion. Everyone watching this knows there's not much to showing reasonable suspicion. You could simply say, boy, the traveler looked nervous to me, right? Or they were going to a country well known for either drug or child pornography activity. The other limitation proposed in the Senate was to limit and prohibit the inspection of digital content, but just for American citizens. I don't know, Erwin, if you have a thought on whether either one of those are likely to survive, but that's how I see what's happening at the searches at the border.
There is a split among the circuits on this issue, so I expect the Supreme Court will take it up. I'm surprised the Supreme Court has not yet taken it up. I used this as a final exam question the last time I taught criminal procedure because I think it's a really hard question and it's hard to predict what the Supreme Court will do. On the one hand, Lori, you're right, of course, that the government has always had broad latitude with regard to searches at the border and searches that don't require reasonable suspicion, let alone probable cause. But the justification for that has been concern about smuggling of people or contraband, and that's not what's being looked for when you're looking at the contents of somebody's cell phone or iPad or laptop. And on the other hand, you've got Riley versus California that you mentioned, where the Supreme Court so emphatically said that our cell phones contain the privacies of life, and therefore, before we allow the police to look at them and see our medical records or financial records, there should be probable cause. And so the question is, how is the Supreme Court going to mediate this tension between, on the one hand, giving the government latitude at the border, but on the other hand, protecting the privacy of life within the cell phone? It is interesting that you mentioned that one of the proposals would give American citizens rights, but not others. On the one hand, once people are in the United States, that's not possible because both citizens and non-citizens have Fourth Amendment rights while they're here. But at the border, before people are here, then can the government draw a distinction? We'll see if Congress adopts such a law.
Okay, thank you. Erwin, I think you're going to take the lead on the next one, which is what is the current state of the law on police excessive force cases, an issue very much in media, but really in our lives throughout this country.
And I think it's very important that we teach the excessive force material in criminal procedure investigation, because it is about the Fourth Amendment, even though it's not about the traditional police searches or arrests. Because I think everyone is familiar here, the two key cases in the Supreme Court were Tennessee versus Garner in 1985, and it said that excessive police force violates the Fourth Amendment, and the court said that the use of deadly force to apprehend a fleeing unarmed suspect violated the Fourth Amendment. And quite important, Graham versus Connor in 1989, the court said there that excessive force claims have to be brought under the Fourth Amendment. Previously, lower courts had allowed excessive force claims to be brought under due process. There was the Second Circuit opinion by Judge Friendly that said that if the use of force shocks the conscience, it violates due process. The Supreme Court said, no, it's got to be brought under the Fourth Amendment, that excessive force is a form of police seizure. And the court in Graham versus Connors said that excessive force is a question of reasonableness from the perspective of the officer at the time. I should mention a case from last term that may therefore be less familiar, Torres versus Madrid, which arose as an excessive force case and was also about what's a seizure. It involves a woman, Roxana Torres, who was in the parking lot of her apartment building in Albuquerque, New Mexico. The police had been called there, not for anything to do with Roxana Torres, but when they got to the parking lot, they saw this woman walking and decided they wanted to question her. Torres got in her car and she saw a man on each side of the car. She thought she was being carjacked and she began to pull out. The men were police officers. They said, "Police, stop." She didn't. They began shooting at her. 2 bullets struck her. Many hit her car and seriously damaged it. She exited the parking lot through a hail of bullets, and she drove to a nearby shopping mall. There was a parking lot, and she saw an unoccupied car with the motor running. She abandoned her damaged car. She stole the car and drove about 70 miles to a hospital where she submitted for treatment of her bullet wounds. The next day, the police came and arrested her. Well, the question was, when was she seized? Which matters because that's the standard for the Fourth Amendment. That's the standard that we look at for excessive force. And the Supreme Court ruled 5-3 that she was seized when there was the application of physical force with the intent to restrain her, even though she was not actually restrained. Once the police hit her, that was a seizure within the meaning of the Fourth Amendment. Justice Gorsuch wrote the dissent and said she wasn't seized until she was arrested. She was driving 70 miles. How can you say she was seized during that time? I think Torres versus Madrid is important in reminding us that excessive force, and that's what this case was about, is litigated under the Fourth Amendment, and also clarifying a bit the standard for what's a seizure. Now, I should mention in terms of the current state of the law that some states, through state legislation, are adopting a different standard for excessive force. Graham versus Connors says it's reasonableness from the perspective of the officer at the time. California has adopted a law that says the use of deadly force must be necessary, not just reasonable. And of course, states can provide more protection of rights than the U.S. Constitution. I don't see any likelihood that the Supreme Court is moving in the direction of necessary rather than reasonable. Of course, even when there is a finding of excessive force, if the police officer is sued for money damages, there is qualified immunity as a defense. I didn't used to teach qualified immunity in the context of criminal procedure. It wasn't in prior editions of our casebook, but now it's so important in thinking about the remedies. A right is meaningless unless there's a remedy, and qualified immunity very much limits the remedy. And often qualified immunity is decided by the Supreme Court in the context of excessive force cases. In fact, there were 2 Supreme Court cases in October 2021 that dealt with qualified immunity in the excessive force context. There were Riva Vegas versus Cordes Luna and City of Tahlequah, Oklahoma versus Bond. Both arose originally in the context of a domestic violence call. Both involved police using force. In both instances, the courts of appeals had ruled against qualified immunity. In each instance, the Supreme Court reversed. And you might have missed these cases because they came down without briefing and oral argument, but they are decisions on the merits. Riva Vegas involved a woman who called the police being threatened by her boyfriend. The police came. They told the man to come out with his hands up. When he lowered his hands, the police fired beanbag rounds at him, pushed him to the ground hard enough to cause injury. He sued. The officer claimed qualified immunity. The Ninth Circuit rejected that and said it would go back to the jury for a trial. The Supreme Court unanimously reversed. The court emphasized there weren't cases on point that showed from either the Ninth Circuit or the Supreme Court that this was excessive force. The other case, City of Tahlequah, Oklahoma respond had even more tragic facts. A woman called, said she felt threatened by her ex-husband. The police came. They found the ex-husband in like a tool shed. The ex-husband picked up a hammer. The police had put down the hammer. He didn't do so immediately. The police shot and killed him. The estate sued the officer for excessive force. The 10th Circuit found it was excessive force and there was no qualified immunity. The Supreme Court unanimously reversed, finding there was qualified immunity, once more stressing the absence of a case with sufficiently identical facts from the Supreme Court or the 10th Circuit. So what does this show? There's been a lot of criticism of qualified immunity, but there's no indication the Supreme Court's about to change the doctrine, and the qualified immunity remains so important in the context of excessive force litigation.
You know, Erwin, I agree. I didn't originally teach the area of excessive force in the regular criminal procedure class, but I think it's key now. And one of the things that you and I have talked about in terms of clarifying the Torres case, that was a civil case. But how does it affect the criminal case? Because we all remember the Hodari decision, where they're chasing after the suspects who are throwing their drugs away as they're being chased, and the court says there is no seizure. Well, what if they're being shot at? Is there no seizure? So, Erwin, do you have a thought about how Torres really changes things in the criminal area, the criminal procedure area, and whether Hodari still seems to be the principle at play?
I don't think it changes the law in the criminal procedure, criminal context, and I think it, in fact, reinforces Hodari. If you remember in Hodari what the issue was, is the police chasing a suspect a seizure, or is it only when the individual is tackled? It involved a person who was running, dropped some drugs while he was running. The officer then tackles him. And the question is, was the chase enough for a seizure? In which case, if there's no reasonable suspicion, the drugs aren't admissible. Or was he only seized when he was tackled? And the Supreme Court, in an opinion by Justice Scalia, said the latter, so the drugs were admissible. The court essentially said it's the application of physical force with the intent to restrain. The chase wasn't enough to do that. Well, I think that's what Torres v. Madrid says. It's the application of physical force by the police with the intent to restrain.
And we don't know, right? What if they're chasing a suspect and they do shoot and they nick him and he keeps going? Do we say that that's a seizure at that point, a la Torres, or do we say he kept going, a la Hodari?
I think once the physical force is applied, Hodari and Torres would lead me to believe that there's a seizure at that time.
The other aspect I was wondering about, and I've had students raise with me, is really the emphasis on reasonableness, which is a standard that is often, quote, in the eyes of the beholder, at least the eyes of the jurors. And then for the judges, too, when they're given their motions to evaluate it. I also know that Justice Thomas, who is increasingly more vocal, both in argument and in the decisions, has always wanted to focus the Fourth Amendment on reasonableness and not specific rules. Do you see the court moving more in that direction, whether it be in this area or other areas?
I think the court is very committed to reasonableness as a test. In fact, if I could talk about the relationship between excessive force and qualified immunity, the test for excessive force is ultimately reasonableness. And I think the test for qualified immunity is ultimately reasonableness. It has to be that an officer violates clearly established law that every reasonable officer should know. In Saucier versus Katz 20 years ago, the Supreme Court said, even though reasonableness is the test for both of these inquiries, they have to be evaluated separately. Was the use of force reasonable? And was the officer protected by qualified immunity, which is about reasonableness? I don't see the court backing away from reasonableness as a standard.
Well, let's move on to our next question, which is very much in people's minds and in the news. What is the law regarding no-knock warrants? And Erwin, do you think it should be changed? Do you think it will be changed? And what is the impact of the recent high visibility cases like Breonna Taylor and others?
Great question. I think all the criminal procedure teachers know that in Wilson versus Arkansas in 1995, the Supreme Court said that generally the police must knock and announce before searching a dwelling. Justice Thomas wrote the opinion and he focused on the law that existed in 1791. But the court left open the possibility of a warrant that authorized a no-knock entry. In Richards versus Wisconsin, a couple years later in 1997, the court refused to create a blanket exception for drug cases, refused to say that in all drug cases that police didn't have to knock and announce because of the likelihood that drugs could be destroyed or flushed down the toilet. But the court said police can get a no-knock warrant. And so if you ask the state of the law with regard to the Fourth Amendment today, it is, with cases like Wilson versus Arkansas and Richards versus Wisconsin said, that police need to knock and announce before they're present. United States versus Banks made clear that police don't have to wait very long before they enter after knocking, but they have to knock and announce unless they get a no-knock warrant. But no-knock warrants are very controversial, and they can endanger the police as well as they can endanger others who are there. We saw that with regard to the death of Breonna Taylor that you alluded to. The police got a no-knock warrant. They entered. A man who was with her didn't know who was entering the apartment. He took a gun. The police saw the gun, began shooting, and Breonna Taylor got killed in the crossfire. Or more recently, on February 2nd, there's Amir Locke. He was a 22-year-old black man. The police got a no-knock warrant and they entered. Locke was not the suspect. Locke was a lawful gun owner. Locke doesn't know who's entering the premises. Locke sees somebody coming in. He picks up his gun. Police yell gun. They start shooting and they kill him. The New York Times did a study that between 2010 and 2016, 81 civilians and 13 police officers were killed when police were executing no-knock warrants. So there's been an effort to try to eliminate no-knock warrants through the political process. By my count, 3 states, Florida, Oregon, and Virginia, have already eliminated no-knock warrants. Many other jurisdictions, Kentucky, New Mexico, Tennessee, are considering doing so. A number of cities have said their police can't use no-knock warrants. Austin, Texas, being an example that did so recently. Minneapolis did so after the death of Amir Locke. There's been a bill in Congress to try to outlaw no-knock warrants. Now, the argument on the other side is there are instances where it would be safer for the police to enter without knocking and announcing first. But the response to that is that the police and all who are present are in danger when police enter without knocking, because then if there's somebody with a gun and they pick it up, not knowing who's coming in, police will see the gun, begin shooting. So, Lori, I think the answer to the question is that I expect there's going to be more political pressure to eliminate no-knock warrants, and I think more jurisdictions will do so.
Erwin, I agree. And I think part of this problem was that we weren't honest about the fact that nearly every drug case was presented to the courts as so dangerous that they had to have a no-knock warrant. And even outside of the no-knock warrant, law enforcement, when they go there, even with a warrant where they should knock, would identify exigent circumstances in those situations and either not knock or wait, as you said, Banks was 15 seconds, 5 seconds. And it's basically the same as a no-knock warrant, where you've got people being barged into. And some of you have seen, you can find them on the YouTube, on the internet, just horrific body camera footage of what happens when they go into a home. There can be children there, there can be families there, and it's a dangerous situation for all involved. And the overriding standard that we have by the Supreme Court is that knock and announce, as you said, Thomas said, is part of the Fourth Amendment, but there's not much of a remedy for it. The governing standard is reasonable, and we haven't really taken a look about how unreasonable it is, given, as you noted, tragically, how many people have been killed. I saw that study, and I saw another study of people looking for it from the Washington Post, where tens of thousands of searches are done in this way. So I do think that it's going to require legislation. As you notice, it's not necessarily the states. Some of them are passing the legislation, but interesting, the local municipalities, who are the ones who are likely to get sued, are the ones who are trying to restrict the use of these in the search. If there's anything else on that, Erwin, if there's not, I'm going to just march to our next subject. And our next subject, there we go. It's going to be regarding the Sarnoff case. And Sarnoff is not a Fourth Amendment case. We know, all of you know that. But it is a Supreme Court decision that came down this term. It came down in March. And there are two major issues in the case. For those of you who recall, Zohar Sarnoff was one of two brothers who was involved in the Boston Marathon bombing. Very significant crime where it impacted the whole community to the point that there was literally tanks driving down the streets of Boston. When you talk about pretrial publicity, everybody knew what happened. Everyone was emotional and very taken by what happened. And Sarnoff got charged. His brother died in a shootout, and Sarnoff got charged with a capital offense. So this was a death penalty case. The judge denied a motion for a change of venue. So there they are in a community where they know people have been affected. The news was continuing. It was just a pivotal moment in the history of the city. And the question is, how do you get a fair jury in that situation? The defense in this case wanted the jurors, prospective jurors, to fill out, they had a 100-question questionnaire, but they wanted to identify which media did you pay attention to in this, which would give more information to the parties and to the court on how to evaluate whether these people could be fair, either for a challenge for cause or for peremptory challenges. And the judge did not do that. The judge asked broadly, and the questionnaire asked about the impact of pretrial publicity and whether they could be fair, but you did not have that type of individual scrutiny nor individual voir dire. And that was one of two key issues that went to the Supreme Court in this case. The other issue was somewhat unrelated, and that may be one that actually got even more attention in the Supreme Court decision. Sarnoff wanted to present third-party culpability type of evidence that his brother, who was wanted for another pretty heinous murder, was the one who had coerced and put the pressure on him. And that would be really important for the death penalty phase of this case, where we're not just evaluating whether he was involved in the crime, but what the punishment would be. And that was disallowed. So those are the issues that go to the Supreme Court, and Justice Thomas writes a decision. And I think it's fair to say, at least in terms of the voir dire process of the pretrial publicity, he continues down the path of skilling. And skilling is one that says, we're not going to put artificial rules on the trial judges. We're not going to use supervisory power to do that or have judges do that. We're simply going to say judges have broad discretion. And here a quote from the decision is so telling. It says, "The right to an impartial jury does not require ignorance. Notorious crimes are almost, as a matter of necessity, brought to the attention of those informed citizens who are best fitted for jury duty." Almost sending the message that certainly it's not enough, and it's never been, to simply know about an offense to be disqualified. But here it's almost embracing the idea that jurors, prospective jurors who know a lot about something may actually be your best fitted jurors. So it is the result in this case, at least on the pretrial publicity, is to give very expansive discretion to judges, both on change of venue and the actual jury selection process. And the dissent in this case, which was Justice Breyer, didn't really focus on this at all. Justice Breyer focused on whether Sarnoff should have been allowed to bring in evidence regarding other allegations or misconduct by his brother. Erwin, did you take anything else away from this case?
I do think it's interesting that 4 times the defense moved to change venue and the judge said no. The judge said, I'll deal with it through voir dire. There's a lengthy voir dire, but from the very beginning of voir dire, the defense and the judge are disagreeing over the nature of the questions. And there is a really important underlying issue, especially in our world of the internet and social media. How should trial courts deal with such high-profile cases? And what the Supreme Court did is just what you said, Lori, give the trial courts tremendous discretion. as to how to handle venue motions, how to handle voir dire. And in fact, as to the second issue in the case, as to whether or not the trial judge should allow in evidence of the other murder in the penalty phase, Justice Thomas says, we give great discretion to the trial judge to decide how to conduct the proceedings. One of the things that I found interesting is the United States Court of Appeals for the First Circuit reversed the death sentence, but didn't reverse the conviction. Nonetheless, the United States government sought Supreme Court review. The Biden administration has imposed a moratorium on the federal death penalty. Last June, Attorney General Merrick Garland said this. Nonetheless, what the government was appealing here was being able to impose the death sentence on Dzhokhar Tsarnaev, and they won in the Supreme Court. Unanimously, it seems, on one issue and 6-3 on the other.
Yeah, I was very surprised by that, given the Biden administration's position overall on the federal death penalty, that this isn't one that they just didn't walk away from because it was raised by the prior administration. But the net result of this is, as you say, very broad discretion to judges on pretrial publicity. And I actually think the second issue is even more disturbing, that in a capital case that you don't give the defendant an opportunity to provide pretty much any type of mitigating evidence to the jury. We have one more area before we take questions, Erwin, and if you'll lead us off on that, it is how does the Supreme Court's recent decision in Thompson versus Clark affect 1983 cases?
It's interesting. There are no cases on this term's docket for the Supreme Court, but what we regard as the traditional Fourth Amendment issues about searches and arrests. Lori, I can't think of another term in recent memory without a single Fourth Amendment case. Last year there were 3, the year before there was 1. But Thompson versus Clark ultimately is a Fourth Amendment case that arises in a different context. It's malicious prosecution. What's involved here is Larry Thompson and his wife had a week-old baby. Larry Thompson's sister-in-law was staying with them. Apparently she had some history of mental illness. And she called 911 and said that she thought that the week-old baby was being sexually abused. There was redness in the buttocks area for the baby. EMTs come, and Thompson says, you're in the wrong place. Well, they go away, and then they come back with the police. And Thompson says, you're not coming in unless you've got a warrant. The officer pushes the door open, throws Thompson to the floor, and they take the baby. The baby was brought to an emergency room and examined. No sexual abuse. The baby had diaper rash. Thompson gets charged with interfering with a police officer in the performance of duties. The prosecutor, I think wisely, decides to drop the charges here. Thompson then sues the police officer who arrested him for malicious prosecution for violating the Fourth Amendment. The district court said Thompson's claim is a sympathetic one, but under Second Circuit precedent, Thompson can't bring a civil suit under 1983 for this Fourth Amendment violation unless Thompson can show an affirmative indication of actual innocence. Well, charges were dismissed. The judge didn't have any occasion to express a view about Thompson's innocence, so there would never be the affirmative indication of actual innocence. The Second Circuit, following its prior decision, says Thompson doesn't have a claim because he can't show an affirmative indication of actual innocence. The Supreme Court, in a 6-3 decision, reverses. Justice Kavanaugh writes for the court. Justice Alito writes the dissent, joined by Justice Thomas and Gorsuch. Justice Kavanaugh says that malicious prosecution can be brought as a claim under the Fourth Amendment, and therefore there can be a 1983 suit, and that there doesn't have to be an affirmative indication of actual innocence. Our system doesn't have a mechanism for an affirmative indication of actual innocence. Justice Kavanaugh says the termination of proceedings in favor of the defendant is sufficient here. Now, the court said that the elements for malicious prosecution of the Fourth Amendment are drawn from the elements that existed for malicious prosecution at common law. Was the prosecution initiated without probable cause? Was it initiated for a purpose other than bringing a suspect to justice? Was there a favorable termination for the defendant? And the court very much is looking at the law that existed in 1871 when Section 1983 was adopted. So why does this case matter? It clearly says that malicious prosecution can be brought as a Fourth Amendment claim via 1983 action. Earlier, the court had said that in Albright versus Oliver, but in a very splintered decision. So I do think this matters for the Fourth Amendment. The court says, and I think this matters as well, that it's sufficient that the proceedings be terminated in favor of the defendant. Let me put this another way. In Heck versus Humphrey, the Supreme Court held that a person who was convicted could not bring a civil suit to be inconsistent with the conviction until the conviction was overturned, such as on appeal or via habeas corpus. If the Supreme Court had extended that to situations where there was no prosecution, that would give prosecutors every incentive to bring charges, knowing that they then dismiss the charges, they couldn't be sued, or the police couldn't be sued for malicious prosecution. Here, the Supreme Court, I think, is taking a common sense approach, saying, since we don't have a mechanism in our system for an affirmative indication of actual innocence, a favorable termination is sufficient.
Erwin, I agree, although I have somewhat of a practical question in my mind, which is whether it might make it more difficult to actually get these timely dismissals. Because in the back of their mind, prosecutors are wondering, am I opening up the door for some type of civil lawsuit? I do not think that's an ethical approach by prosecutors, but I have certainly heard of that happening. So overall, the decision seems, as you described, absolutely correct. What the practical effect of it is something that I think we're going to have to wait and see and have the courts enforce.
Recently, I was speaking at a judicial conference, something you and I do, and a judge came up to me and said, what if some charges get dismissed and other charges don't get dismissed? Can there then be a suit for malicious prosecution? Can you have a suit for malicious prosecution as to the charge that were dismissed if other charges remain? That's certainly an open question.
Right. Well, speaking of questions, I think we're at that point of having some questions. We'd love to answer any questions you might have. At this point, I think Neil's going to be taking over the questioning for us. And I do want to emphasize that if we don't get to your question, you'll be able to reach us individually and we will get you answers. That's what our commitment is, both writing this book and just doing this program. We want to be there as a resource for you.
Great. Thank you. And thank you both for your presentation today. We have now reached the Q&A portion of the webinar. As a reminder, if you would like to ask a question, you can please type it into the chat box to the right of your screen, and I will read it aloud to our presenters. It looks like we do have a few questions already, so let's get started. First question is, how do you expect the new composition of the Supreme Court to affect Fourth Amendment cases?
Well, let me start here, and I'll be interested in what you think, Lori. Overall, Justice Jackson replacing Justice Breyer doesn't change the ideological makeup of the court. It will still have 6 conservative justices who have been appointed by Republican presidents and 3 liberal justices appointed by Democratic presidents. But when you look at the Fourth Amendment, it's more complicated than that. Justice Breyer has often been with the conservatives, especially in the last decade in Fourth Amendment cases, sometimes the decisive vote. All of us as criminal procedure teachers teach Maryland versus King, which is about whether the police can take DNA from a suspect who's arrested for a serious crime to see if it matches an unsolved crime in the police database. That was 5-4 in favor of the state, with Justice Breyer being in the majority and Justice Scalia joining Justices Ginsburg, Sotomayor, and Kagan. Or think of Navarrete versus California. Is an anonymous tip that a driver was driving erratically enough to pull over the car without the officer needing to observe the erratic driving. 5-4, again, with Justice Breyer joining the conservatives and Justice Scalia writing an emphatic dissent for the liberals. Or Utah versus Strieff in 2016. That was the question of, if the police illegally stop somebody, but then discover there's an outstanding warrant, can they arrest the person and search instant of the arrest? And the Supreme Court 5-3 said yes. Justice Breyer joining with the conservatives. There were only 8 justices the year that Justice Scalia passed away. I think that Justice Jackson in those cases might have been much more likely to agree with the liberal justices than agree with the conservative justices. So replacing Justice Breyer might make a difference. Also, we can't forget that Justice Jackson is the first public defender to ever go onto the Supreme Court. And in discussing cases, that perspective might have an influence on the other members of the court.
You know, my thoughts are a little different from that, in that I think that the conservative voices on the court are the governing voices right now. And in the Fourth Amendment area, we've always had this tension about whether we're going to follow the historical rules on probable cause and the other requirements for a warrant, or just generally see them as reasonable, and having the justices decide, notwithstanding prior standards, it's still reasonable. I also think there will be questions about how much ongoing commitment there might be to the exclusionary rule. I don't disagree with Irwin in terms of replacing Breyer with Jackson, but I think that there's a reality in having Justice Thomas's voice being such a substantial voice in the Fourth Amendment as well as other areas.
I actually agree with that. I don't think there's any disagreement on this. Something you say I want to highlight, and that's the importance for this court of history. Last term, in 2 of the 3 Fourth Amendment cases, Torres v. Purdue we talked about, and Lang versus California, the Supreme Court very much focused on the laws that existed in 1791 when the Fourth Amendment was ratified. Now, one of those was written by Chief Justice Roberts, but the other was written by Justice Kagan, and she was very much focusing on the law as it existed in 1791 in terms of police being able to enter a dwelling in hot pursuit. I mentioned other cases as well where the court's focusing on is, well, what was the law at the time 1983 was adopted? What I tell my students is, if you're litigating a Fourth Amendment case, certainly in the Supreme Court, but often now in courts of appeals and maybe in trial courts, what you really need is a copy of Blackstone and being able to research the law that existed in 1791. And so, Lori, I think that's where we find very much the influence of the conservative justices in their focus on originalism and original meaning.
Okay, thank you both. We have a number of questions coming in, so I'm going to move to the next one. This is going back to border searches. Are there international norms among democratic countries relating to their suspicionless electronic searches at their borders? Are we an outlier?
Erwin, that's an interesting question. I'm not sure I know the answer. I only know it from traveling. I have not had or seen the occasion under which they search, but I'm wondering whether countries like Thailand or others that are most suspicious do these type of searches. Do you know?
I don't know. It's a great question.
We'll get you the answer. We've got, we will figure it out. So thank you. And hopefully you put in chat who you are so we can get the answer to you.
Yeah, definitely. We have that information, and we will get back to that attendee. But thank you for that question. The next question goes back to the no-knock. Isn't time of execution of warrant also an issue? Even if knocking, if it's the middle of the night, it is not likely to be heard.
Right. That's actually an issue of the federal rules and what time is allowed for the searches of places. So there's supposed to be daytime searches unless you've gotten an after-hour search. And that adds to the danger because daytime is actually quite early. I think it's 6 a.m. until 10 p.m. That's quite a window. But after that, people are sleeping, people are surprised. Yet, as the question suggests, many judges will authorize those late warrants because, again, they want to give law enforcement the advantage of not being in danger when they go in. And I do think that adds to the problem as well.
And I think what the question points out is that even if we eliminated no-knock warrants, if police can execute the warrants at night, they knock when nobody is there, they knock softly, they go in after 15 seconds, like in the Banks case, you're basically in the same situation as the no-knock warrant. But Lori, what you mentioned in terms of the federal rules of criminal procedure, many states don't have similar limits with regard to encouraging daytime as opposed to nighttime searches. And even where there are the federal rules, judges in drug cases are so inclined to grant the request for no-knock warrants.
Yes.
Okay, thank you. The next question we have, anything in the draft opinion reversing Roe Casey that might impact or foreshadow any criminal procedure issues?
Erwin, I'll let you start on that one.
Yes. I mean, let's start with stare decisis. I think that the draft opinion shows little regard for precedent. A couple of years ago, Justice Breyer, in a dissent, said there has to be a better reason for overruling a precedent than 5 members of this court disagree with it. I don't think there is that with regard to Dobbs versus Mississippi. So once the court says that precedent isn't going to matter, and I think in other cases too, this court hasn't shown much regard for precedent, I think that, of course, could have enormous implications for other areas. Lori mentioned the exclusionary rule. In Hudson versus Michigan, 4 justices essentially called for the elimination of the exclusionary rule. Justice Kennedy was the 5th in the majority there, and he said the continued operation of the exclusionary rule is not in doubt. But now with a very different court, the exclusionary rule might be very much in doubt. Or we could talk about, will this court continue to adhere to Miranda, or the ability to raise Miranda on habeas corpus? Also, the draft opinion by Justice Alito says that a right should be protected only if it's in the text, or as part of the original meaning, or the long unbroken tradition. Well, that raises questions about rights that have been protected in the context of criminal procedure. Think of eyewitness identification, which I think is an area where the Supreme Court has ignored an enormous problem because we know of so many wrongful convictions, including exposed by Lori's project, that resulted from eyewitness identification. United States versus Wade says you have a right to an attorney at a post-indictment lineup. Well, I don't know you can reconcile that with the 3-part approach that Justice Alito takes. There's nothing in the Constitution about it. I don't think it was part of the original meaning. There was certainly no tradition prior to 1968. And if 1973 isn't enough for a long tradition, nor would 1968. The only caution that I'd point to is we saw a draft opinion. And while I don't expect the result is likely to change between now and the end of June, I think there are 5 votes to overrule Roe, the way in which the opinion is written certainly could change.
And I think that, in fact, we already saw this last term in terms of retroactivity of rights, where Kavanaugh said we're not going to do that anymore because we don't have watershed rights anymore. So that sort of is gone even now with this new position of the court. I think you need to unmute, Neil.
To unmute.
Apologies. Thank you very much for that. So before I do get to the next question, I did get a question about this presentation and a replay. So I just want to take a minute to let everyone in the audience know that this is being recorded and you will receive an email most likely tomorrow, usually within 24 hours, with a link to the replay. So you will have that. The next question I have is, in Jones, Justice Scalia said Katz added to the Olmstead trespass test. It did not replace it. He said that again in Jardines. Justice Black dissented in Katz and said the majority overruled Olmstead. Was Justice Scalia correct when he said Katz added to Olmstead rather than replaced it?
I think that's what his intent was and how it's being interpreted by the court. So it is true that we still ask about whether you have a subjective expectation of privacy and whether it's reasonable. But we also ask about whether Freddie the dog on your doorstep is a trespass. I think he had to combine them because practically, I'm not sure we would be able to go back to trespass law and find enough there to really inform us on how to apply the Fourth Amendment. Erwin, you have a thought?
I agree, though I might phrase it a little bit differently. Olmstead focused exclusively on whether there was a trespass, whether there was an invasion of property rights. Katz in 1967, as rightly pointed out, says, we're going to shift to the reasonable expectation of privacy. I think what Justice Scalia is saying in Jones and Jardine is that you can find it to be a search either by finding it to be a trespass or an invasion of the reasonable expectation of privacy. Now, I would then go back to something I said earlier. I would pay attention to Justices Thomas's and Gorsuch's dissent and Carpenter. Each of them in a separate dissent said that we should focus only on whether there's an invasion of property rights. As I mentioned, Thomas could not be more critical of the Katz invasion of privacy standard. I don't think they've got 5 votes, but they may have at least 3 now with Barrett joining them and perhaps more. So this, where I think we are now, is invasion of property or invasion of privacy is enough for a search. We at least have 2 and maybe 3 justices who want to go back to Olmsted.
Got it. And thank you. Our next question is thoughts on whether Gantt-like limits on SIA car searches will be extended to grab area and arrestee person SIAs, whether the issue will be addressed anytime soon.
Well, that's a very interesting question because, Scalia was so important to that. The justices who were so important to that decision are no longer there. And Gantt itself was such a compromise decision, right? So, they didn't know what to do with the Belton search incident to an arrest because the person's locked in the back of a patrol car. And Scalia wanted to go with Jefferson buggy question he asked during argument, which is, if Thomas Jefferson were arrested in his buggy, couldn't you search the whole buggy? So they came up with this compromise decision. I haven't seen cases, Erwin, that's going up to the court to sort of reevaluate that because I think it's been workable for law enforcement. But do you have some thoughts on that?
There's one other part of Gantt that I think is causing some confusion in the lower courts. Gantt itself seems common sense. If we were allowing a search of the area of the car where the driver was so as to protect the officer, if the driver is restrained away from the car, then why allow that search? And I think that's why Gantt qualifies Belton as it does. But there's also language in Gantt that says, but there's an exception if the basis for the search was the basis for the stop originally. So if the reason the police are stopping the car is the reason they're searching, then they can do that. And that, I think, is causing confusion in the lower court. And that really goes beyond the common sense limit with regard to Belton.
I think another part that's confusing for people is the idea that you can search the passenger compartment if you have probable cause based upon the nature of the stop, but not the trunk. And I think that Scalia wanted the entire vehicle. So that may be where the push comes in upcoming cases.
Okay, thank you. I just had another question come in. This is about warrants authorizing knock and announce. The question is, isn't a major concern that judges are not critically reading the underlying factual predication to support foregoing K and A, or am I being unfair?
Oh.
I've always been concerned about boilerplate language in affidavits.
Phil, you're not being unfair. I can see who's writing in, and thank you for the question.
Yep.
You're not being unfair because some of the studies show that, and it's not fair to paint all the magistrates and judges, but many times they very quickly or see as a form type of application, and they're not asking the tough questions. Frankly, if they were, I'm not sure we would be having as many problems as we have. So do we design rules for magistrates that we know will be very conscientious, or do we design rules for the practicality of what's happening out there?
The only thing that I add is the obvious, that from everything I've heard, there's tremendous variations among magistrate judges and judges. And some do read very carefully, some rubber stamp what's put before them.
Okay. And I think we have time for one more question. So it's coming in from Nicholas. Doesn't Gorsuch's conception of property rights in his Carpenter dissent suggest a potential broader framework than Olmsted?
Yes. I mean, what Justice Gorsuch wanted to focus on was much more the property rights of the cellular phone company and how they may be affected. And that's different than just the notion of trespass, which was Olmsted. Where Gorsuch is going to take this, we don't know, because Gorsuch also says in the dissent, no one raised that issue in this case. But yes, I think Gorsuch's conception is a broader one with regard to property than what Olmsted articulated in 1928.
And I think it's particularly problematic in light of Riley, where Chief Justice Roberts noted that if we just focus on the property rights of the cellular phone company, we're really missing the practicality here that, in fact, everybody uses these phones, and you don't have a way to set up your own phone company. And so to just focus on the rights of the phone company doesn't provide any protection for all of us who are out there using the phones.
Okay, thank you. I think at this time, I do want to give our presenters a few minutes for final remarks. So I will collect any other questions that come in and make sure to circulate them after the webinar. But again, thank you both for your presentation, and just want to hand it back over to you for any final remarks you may have.
I'm going to give Erwin the final remarks. I'm going to simply say thank you so much for joining us. And we look forward to ongoing conversations. You know how to reach us, and your questions have been fantastic. And if you have additional ideas as you use our book, if you're using our book, we welcome those comments as well. We do annual supplements, and that's one place where we can add that information. And of course, every edition, we try to make sure everything is there that you need, which is why we've added the sections on civil cases and excessive force. Erwin?
Lori said what I wanted to. Again, thank you so much for joining us, and thank you for using our book, and we welcome your suggestions. I think this is a very exciting time to be teaching criminal procedure or anything with regard to constitutional law. We're on the verge of so many major changes. In the Fourth Amendment context, a lot of this is coming because of new technology, but it's also coming from a court that's so focused on interpreting the Constitution from an originalist perspective. So again, thank you so much.
Thank you, and thank you, Erwin.
Thank you so much, Erwin and Lori. Thank you for a fantastic webinar, and thank you to everyone that has joined us. And also, please feel free to reach out to me, to anyone at Aspen, with any questions. We're happy to hear from you and to help in what way we can. So thank you.
Okay, the webinar has now ended. Thank you for attending, and we hope you have a great rest of your day.